बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलामु अलैका या रसूलुल्लाह वसल्लम अलैका या हबीबल्लाह। प्यारे व्यूवर्स, उम्मीद करता हूँ आप तमाम दोस्त सब खैरियत से होंगे। अल्लाह ताला आपको सेहत के साथ लंबी ज़िंदगी अता फरमाए। मेरी तमाम दोस्तों से रिक्वेस्ट है कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। कल हमने पढ़ा था फर्स्ट इंफॉर्मेशन रिपोर्ट टू द पुलिस। आज सेकंड FIR पढ़ेंगे इंशाल्लाह। तो शुरू करते हैं। सेकंड FIR नॉट बेयर्ड 1996 PCR LJ 499 PLJ 2000 LH 1341 क्रॉस वर्शन सेपरेट चलान नॉट नेसेसरी। 1996 PCR LJ 1294 नॉट गॉस्पल ट्रुथ PLJ 1996 LH 1139 फोटो कापी क्वालिफाइज टू बी ए रिपोर्ट PLJ 1996 SC 1313 1713 पुलिस ऑफिसर्स अंडर स्टेचुटरी obligation to enter the information relating to the commission of a cognizable offence in the prescribed register PLD 1997 LH 135 registration of second FIR embodying the counter version of a case is neither legally barred nor can be refused PLG 1998 LH 111 however provisions of Section 154 do not conceive second FIR with regard to same occurrence 1999 PCR LJ 1706 in case of controversion disclosing distinct and separate offence need to be registered PLJ 1999 LH 157 NLR 1999 CR LH 98 dispute about time of occurrence, place of occurrence and manner of occurrence would furnish legal justification or for registration of second FIR NLR 1998 CR BWP 48 1995 PCR LJ 1239 1993 PCR LJ 1992 1056 1993 MLD 2059 depends upon the facts of each case 1999 PCR LJ 1706 in the multiplicated version, especially when the first reported version is denied, the later version can be taken into consideration 2004 PCR LJ 470 FIR recorded after parliamentary investigation would lose its sanctity and probate worth 2004 PCR LJ 1239 first by a manner number 3 first by a manner can be lodged by a manner 1999 PCR LJ 694 Number 4 registration of FIR requirement of law is that police officer has to record for mandatorily of a cognizable case under Section 154 CRPC, but where it is a non-cognizable case when substance of such information is to be entered in the relevant register, but each case refusal to register case is out of question 2000 PCR LJ 320 1999 PCR LJ 781 Police has नो jurisdiction to cause delay 2001 SCMR 424 provision of section 154 are peremptory as well as obligatory in nature. Violation initials penal action under section 29 of police rules 1861 PLD 1999 LH 417 use of word shall indicates that it has been used in the mandatory sense and does not allow any directionary powers to the officer in charge of a police station who has no choice but to register the complaint in the prescribed book if information of cognizable offense is given to him by any person. Those are those. PCRLJ 2007 Proceedings may be initiated under section 156 under section 6 156 under 3 or ART article 199 Constitution of Pakistan PLD 1999 LH 417 declaring the information in writing by police as the instance of the information is imperative in law. PLD 2000 LH 208 police to make investigation no justification to ask court for cancellation of case or to release the accused under section 160 2001 MLD 1096 registration of criminal case is independent right of aggrieved person PLD 2002 LH 78 such exoneration does not constitute bar even to private complaint which is another mode of bringing culprits for trial before court of competent jurisdiction PLD 2002 LH and treats as FIR PLJ 2001 SC AJK 166 2001 PCRLJ 827 Whereas every information relating to the commission of a cognizable offense as used in under section 154 pertains only to information supplied and do not pertain to actual commission of a cognizable offense. Information supplied should be about alleged commission of a cognizable offense irrespective of the fact whether such information is ultimately proved to be correct or not, and also irrespective of the fact whether ultimately such offense was found to have been actually committed or not. PLJ 2004 LH 102 Number 5th, death in police custody. Death in police custody. Complainant and eyewitnesses seeing police giving chitter blows on buttocks of the deceased. Cause of death relevant cure the offence under section 302 PPC, but it had no bearing cure other offences of illegal arrest, confinement and inflicting injuries during police custody PLD 2002 LH 78. Number 6, two versions where a distinct and separate cognizable offence is disclosed and no effective injuries or trial can be held held without properly appreciating and consideration the two versions, and other FIR is to be registered 2000 PCR LJ 320. Number 7, statement by injured person. Statement given by injured person to IO and also FIR lodged by him not admissible as dying declaration AIR 1999 SC 3883. Number 8, supplementary statement. Supplementary statement not equated with FIR, it cannot be considered or read as part of FIR. FIR is documents which is entered into a book maintained at the police station and the thumb marked or signed by the first information, while the supplementary statement is recorded under Section 161 and is not signed PLD 2002 LH 110. Object of further statement is not to enable complainant to clarify facts which required some explanation, but if completion of case is changed as regard identity of culprits, then onus would be on prosecution to cast away the same of trial, same at trial. Court for purpose of bail would be persuaded to draw reasonable inference that guilt of a person involved on basis of further statement without rational explanation would call for further inquiry. PLD 2002 KAR 402, recording of supplementary statement by the informant with different version after lodging FIR, no request made for cancellation of FIR, substituting the same with the supplementary statement. Legally, no reliance can be placed on supplementary statement. It is no more than a statement of the complainant under Section 161 CRPC 2003 YLR 1419. Number 9, primary object of FIR under this section is to convey information about commission of a cognizable offence which is a police officer is competent to investigate as contemplated under Section 156 CRPC. It is meant to set in motion investigating agency to probe into the commission of offence and unearth the truth. Those are the PCRLJ 1785. Object of FIR is to set investigation agency of the state in motion so as to collect evidence. Those are 4 YLR 447. 10. Number 10, Section 161 CRPC, read with Article 199 of the Constitution. Police officer under statutory obligation to register case where the complainant discloses a cognizable offence 1992 PCR LJ 1999. It is their mandatory duty 1993 SCMR 550 1994 PCR LJ 798 1995 PCR LJ 1239 in the event of failure liable to be dealt with by his superior officers for negligent of duty PLD 1992 LAH 493. Police officer cannot refuse to register a case where a cognizable offence is made out 1990 PCR LJ 2006 1811 statutory duty to trace read with real culprits 1994 MLD 1736. Investigation of agency after reaching a positive conclusion can challan other party in some FIR if it finds commission of cognizable offence PLJ 1993 LH 12 FIR founded false and without any substance after investigation to refer the matter back not in the interest of justice. Remedy to file complaint PLD 1993 LH 18 after the judicial inquiry resulting in the exoneration of accused. No useful purpose can be served in directing registration of the case 1993 PCR LJ 200. Direction to register a case against accused made by High Court under Article 199 of the Constitution PLD 2005 CRPC PSH 139. So far as investigation is concerned, recording of FIR is not a condition precedent PLD 1994 LH 485. Two remedies, criminal and civil, can be pursued simultaneously 1995 MLD 1473. Availability of an alternative remedy by way of filing of a complaint in itself does exclude the jurisdiction of High Court vested in it under Article 199 of the Constitution, being its prerogation to adopt the same or not in order to regulate its constitutional jurisdiction. High Court cannot close its eyes to the glaring exercise of excesses of jurisdiction or use of culpable authority by the state functionaries, and thus even in the presence of an alternative remedy, High Court can assume jurisdiction to direct the police officers to comply with the order of Session Court in letter and separate 2004 PCR LJ 1864. Number 11, controversial restricted to offence version. The second version are a different version of incident. Second FIR cannot be recorded but where a distinct and separate cognizable offence is disclosed and no effective injury or trial can be held without properly appreciating and considering the true version, then another FIR is to be recorded. PLD 1999, LH 50 in the latter case, police duty bound and obliged obliged to record same and register FIR 1999 PCRLJ 512 most efficacious remedy to file private complaint 2000 PCRLJ stat. Number 12 counter affidavit. Counter affidavit, where serious allegations are made against the accused person in constitutional petition, the registration of FIR cannot be denied on the basis of counter affidavits. 2002 PCRLJ 2007. Delay in lodging FIR is condonable, keeping in law facts and circumstances of such case. However, heavy duty is cast upon prosecution to explain the same. Otherwise, the prosecution case would become debatable. PLJ 2004 SC 552. Expectation for making payment to no ground. PLJ 1999 CRC LAH 330. Delay not in all cases conclusive proof of truth or otherwise of a case of FIR PLD 2002 CRC KAR 275 PLD 2002 KAR 152 PLJ 2005 CRC LAH 1026. Delay of 7 or 8 days in lodging FIR relating to offence of Zanab al-Jabr cannot be considered fatal in presence of positive report of doctor and serologist. PLJ 2003 SC 921. 14. Discharge of accused. Discharge of accused in an administrative order does not block judicial order of summoning of accused by court of law 2000 PCR LJ 595. Order of discharge made on police report under Section 173 CRPC right course to seek permission to reopen case in the absence of permission. Cognizance of subsequent report can be refused. 2000 PCRLJ 580. Number 15. Offence failing within jurisdiction of FIA. Report for registration of a case to conduct investigation to a cognizable offence failing within the jurisdiction of FIA is report under Section 154 CRPC 1998 PCRLJ 958. Number 16. Registration of cases effect. Registration of case does not mean that persons against whom allegations are levelled in FIR are in fact guilty of the offences. Question of guilt or innocence depends on investigation. NLR 1998 CR Quetta 161. Not a condition precedent for investigation 1992. KLR CR 58. Police officer bound to comply with order of DSP 1991 PCRLJ 537 not a substantial piece of evidence 1991 PCRLJ 1117 1992 KLR CR 471 evidentiary value can be used to corroborate statement made by the complainant or confront the same 1991 PCRLJ 1480 SCMR 1608 1992 PSC 176 SAPPC connotation 1991 PCRLJ 2007 police officer should register a case and then form an opinion whether the facts stated in the FIR are true or not 1991 PCRLJ 1125 second statement nor FIR 1991 PCRLJ 247 delay of 3 hours 1992 KLR CR 383 report apprehension disclosing information as to the commission of cognizable offence SHO bound to regard FIR 1992 PCRLJ 512 2236 1999 merely sits and motion the criminal law not a place piece of substantive evidence 2001 SCMR 1556 1992 MLD 1922 no substantive second FIR is permissible on the facts and allegation on the basis of which an FIR already registered 1997 PCRLJ 1167 officer under obligation to investigate cognizable offence whenever report NLR 1999 CR LH 300 police in the absence of any FIR cannot arrest and proceed 2000 PCRLJ 1148 transfer of investigation Chief Minister of a province is not conferred with any power to order the transfer of investigation of a criminal case from one police officer to another 1998 PCRLJ 1726 Number 18 WP Anti-Corruption Establishment Order of 1961 case of covered by schedule against public servants in performance of their functions as public servants can be registered under Section 154 at ordinary police station established under Section CRPC under CRPC and Police Act NLR 1999 CR LH 161 under 2 in charge of police station of anti-corruption establishment also acts under Section 154 CRPC with respect to the registration of FIR regarding offences to be investigated by them 2000 PCRLJ 1924 filling of civil suit mere filling of a civil suit is not barred to the registration of criminal case if sum is made out from facts asserted that a criminal fact is committed 1998 PCRLJ 1269. 19. Registration of cases against police officers. पुलिस ऑफिसर्स के खिलाफ कैसे FIR दर्ज होती है? मदर ऑफ डिसीज्ड चार्जिंग पुलिस ऑफिसर एंड attributing specified rule to them for murder of her son. Police not possessed with right to murder or kill or take life of any citizen accused of an offense only for the reasons of that such person was involved in criminal cases and kept a previous bad record. Police direct to register case PLD 2000 PASH 3. Police was no license to murder an accused of 1991 FIR PLJ 2003 LAH 61. Number 20. Duty of police. Police is duty bound to conduct investigation justly and fairly without having influence from the endorsement of higher officers. 1999 PCRLJ 1193 police officer is duty bound to investigate a case in which FIR has been registered. Such power continues even after submission of challan in the court. PLJ KAR 147 DB superior police officer was not competent to allow investigation of the case when FIR had been cancelled under the orders of magistrate. PLJ 2005 CRC KAR 147 DB FIR was directly lodged against the separate of Section 195A CRPC, consequently quashed by High Court. PLJ 2001 CRC LAH 128 2001 PCR LJ 593 NLR 2001 CRL 97. Number 21 false information. Police under obligation to register a case legislation has placed check and balance through Section 182 PPC 1900 PCRLJ 1645. Number 22 quashing of FIR. Investigation malified and without jurisdiction. High Court competent to correct such proceedings and pass necessary orders to ensure justice and fair play. 1996 SCMR 24 PLD 1971 SC 677 FOL. High Court cannot assume the role of investigator. 1994 SCMR 2142 Supreme Court disapproved the direction of the High Court to submit periodical report regarding the progress of the case. PLD 1994 SC 2218. However, High Court can correct proceedings of the investigating agency based on malified in fact and malified in law. PLD 2000 LAH except question of FIR during investigation tantamount to throttling the investigation which is not permissible to law. PLD 2003 KR 309 case was not found malified or baseless. Questioning of FIR was refused. PLJ 2003 CRC LH 59. Delay of 11 months in reporting matter to police. FIR to be quashed not necessary to police before magistrate for order of discharge. PLD 2000 LH 1343. Two complainants in one FIR and incompetent. PLJ 2000 LH 1325. Original agreement to sell are yet to be recovered from petitioner possession. Police would be in a better position to recover the same than the civil court when where an suit is pending relating to genuineness or otherwise of the same. No case for declaring FIR to be without lawful authority and of no legal effect made out. PLJ 2004 CRC LH 102. Number 23. Power of High Court. High Court has no power to